just keep you from putting our kids in the ground. So we can't stand down. No, we won't back down. We won't back down, baby. There ain't no easy way out. We can't stand down, brother. So we'll stand our ground. And no, we won't back down. 'Cause we know what's right. And we got plenty of fight. And if you think you're gonna keep pushing us around, well, you'll lose that crown. 'Cause we won't back down. We won't back down, baby. There ain't no easy way out. We can't back down, brother. We've got to stand our ground. And no, we won't back down. You know, it's pretty clear. If these lunatics think they have the right to strip us of our rights of self-defense, and if they're willing to do that, what else are they willing to do? We won't back down, baby. There ain't no easy way out. We can't back down, brother. No, we won't back down. Back down, baby. There ain't no easy way out. We can't back down, brother. We've got to stand our ground. So we won't back down. No, we won't back down. Virginians, you won't fight this fight alone.
Hello, everybody. Happy Sunday and welcome, and thank you for joining us. We have John Pierce, an attorney with VCDL, and of course, Philip Van Cleve and Jill McDaniel. So, John is here to talk to us today about mistakes that people can make on the concealed handgun permit application that could potentially land you in jail. So, John, if you would like to get into it, I'm sure everybody's anxious to hear.
Absolutely. So, as the intro that is sitting on my picture so aptly says, in addition to being on the board of VCDL, I'm also an attorney here in Virginia. Specifically, I'm an attorney whose practice focuses on firearms law primarily. And I do a lot of cases where people, for example, try to buy a firearm. They don't realize that maybe some mental health treatment that they got in the past disqualifies them, and they answer a question incorrectly. And Virginia has for a long time had a standing statute called false statement on a background consent form. It is a felony, and they charge that quite frequently. But it's very similar to perjury in that it is a willful misstatement of a material fact on a form that has been attested to under penalty of perjury. And so we have a long history of those kind of charges. But over the last year, I will say, I've been seeing a disturbing trend that at least I, in my practice, and some of the other people that I work with, have not seen before. And that is cases where the Commonwealth attorney in various jurisdictions is charging people at the felony level for felony perjury when they make a mistake filling out the concealed handgun permit application. And there's any number of questions on here that are long, confusing, and have a great deal of sort of legal behind the scenes content that you need to be aware of and you need to think about when you're filling out these applications. You know, historically, people would fill these out fairly quickly. They would send them in. And if there was something that they got wrong, they would get a denial. We would request an ora tennis hearing in front of the circuit court judge. We would go in front of the circuit court judge. They would apologize for the mistake. They would provide the requested information. And again, we're not talking about information that necessarily would prohibit you from getting a concealed carry permit. We're simply talking about incorrect information. And then, of course, then the judge would make the final decision and usually issue the permit. And the person would know not to make that mistake on that question again. What we've been seeing is more and more jurisdictions are willing to actually prosecute applicants for perjury when they make a mistake. And I just want to go over a couple of the questions here. When I say a couple, it's a significant number of questions here on the concealed handgun application that you could get wrong, even though you're not prohibited from getting a concealed handgun permit. So let's go ahead and just look at the very first one, 8A. Have you ever been convicted of a felony offense? Well, let's start right there. Everyone sort of immediately jumps to, well, that's an easy one. Not necessarily. Remember, Virginia has a robust gun rights restoration process. We help people get their gun rights back after they have rehabilitated themselves all the time. And so you may have been convicted of a felony, have had your gun rights restored, are eligible to apply for a concealed handgun permit, but you need to disclose that on the application. So, and for those of you who might be listening or who listen to this later on, who've had your rights restored, if I did your restoration, I always send out a closing email at the end that reminds people, here's how you fill out the application when you buy a gun. Here's how you fill out the application when you apply for a concealed carry. And that application is when you apply to buy a gun, one of the exceptions allows you to say no to the question of, have you ever been convicted of a felony? And everyone gets really happy about being able to say no to that question when they buy a gun. That is not the case on this application. On this application, it says, have you ever been convicted of a felony offense? You have to say yes, and you'll see later in the question, it then directs us to the second page to provide context and whether or not your rights have been restored. So number one, if you're a restored person, you need to say yes and go to the second page and include more details. It goes on to say, include felony convictions or any offense for which you were convicted or adjudicated as a juvenile, which would have been a felony if committed by an adult. That's the other thing that throws people, and I've had to represent people on. We automatically in Virginia restore gun rights to those who have a juvenile felony adjudication on their 29th birthday. And in fact, in certain circumstances, you can have those restored before your 29th birthday. And again, those people, either after their 29th birthday or after having them restored earlier, those people can say no to the question of, have you ever been convicted of a felony on the background check form. However, on this form, you have to say yes and go to the second page and describe what the felony adjudication you had as a juvenile was, and then what your restoration was, whether it was automatic at 29 or whether you got a earlier restoration. And again, it says, if yes to any of this question, complete Form 1, Part B on page 2. Failure to acknowledge a conviction may be construed as making a materially false statement. And I've had a number of people that have learned that the hard way in various jurisdictions across the state. So that's the one I wanted to start with, but that's not where we're going to end. Now, the question, or A2, have you been convicted of A, meaning any, misdemeanor offense within the 5 year immediately preceding this application? Again, a lot of people read into that because they're familiar with 18230809, and they know that only certain misdemeanors prohibit you, and those certain misdemeanors might have a 3 year limit, or if you have 2 or more within a certain period of time. And so they're like, well, yes, 5 years ago I had a misdemeanor for fishing without a license or something ridiculously tiny, and they say no to this question. I literally represented someone last week whose charge was based on the fact that they had a misdemeanor. It was 4 years, 11 months prior to their application. And one of the jurisdictions in Virginia charged them for that. Even though it was not a prohibitor and they could get their concealed carry, they were charged with a felony because they miscounted months. It does say here, do not include traffic infractions or those misdemeanors set forth in Title 46.2 of the Code of Virginia, which, as we know, all applicants are extremely well versed in where we put things in the chapters in Virginia Code. I find it very unfair, but you don't include any of the traffic offenses that are non-DUI, non-vehicular manslaughter, or those kind of things. Of course, those would be a felony, but you see what I'm saying? So my advice to my clients is, if you have a misdemeanor, even if it is a traffic misdemeanor, say yes, put it on the second page, and let them say, oh, you overshared because of what we've been seeing. Then you come on down here to question 8D. Have you been involuntarily admitted for mental health treatment? Everyone goes, no, I have not. But that's not where this question ends. It goes on to say, or were you the subject of a temporary detention order and later agreed to voluntary admission? Remember, that is a prohibitor for purchasing, owning a firearm, as well as a concealed handgun permit. And if I had to list out the various causes that people get caught up in when I represent them on these felony charges, that's the one that gets the most people, because they know that they voluntarily agreed to get the treatment, and they don't realize that that is a secondary state level prohibitor in Virginia. It's not a federal prohibitor, but it is a Virginia prohibitor. Question E, have you received mental health or substance abuse treatment in a residential setting? That's not one that I see a lot of people get wrong, but I do get a ton of questions about it. So I just wanted to address that for the audience here today. When that says in a residential setting, that means you had a bed there and you stayed there for some period of time. Doesn't have to be a long period of time, but if you had a bed at a facility and you got substance abuse treatment, let's say that tomorrow I decide that I have to get off the caffeine and I go to a Mountain Dew Anonymous treatment center where they give me a bed and I stay there 3 days. That would then prohibit me for 5 years from the date that my last day of being there, from applying for a concealed handgun permit. But in a residential setting, only applies if you had a bed there. Of course, there's a number of others here that we don't see people getting wrong a lot, but certainly if you are named as a respondent in a restraining order or protective order, the only thing I'll mention there is if you're in the middle of an active divorce case, oftentimes intermediate orders from a family court will have a mutual, protective order between the two of you just as a matter of default. If you're going through such a case, talk to your attorney about the fact that you're a gun owner and make sure that you're aware of that before submitting this application. Coming on down, then like question L here, have you within the 3-year period immediately preceding the date of the application. And then they go into some specific misdemeanors. Those, just make sure you read the question. I don't see a lot of people getting those wrong because we're getting closer to today. They remember more, and it goes into greater detail. And then finally, we've got a new question in on this form. Since we added the 3-year domestic violence with the purported restoration that Virginia is doing. And again, that definition is not the federal definition. It is the slightly more expansive state level definition. And I guess what I'll say there, if you've had any sort of assault and battery conviction at all, where the victim was your spouse, anyone you've ever dated, anyone you've ever had an intimate relationship with, one of your children, the children of any of the other people I've described. And that would include things such as convictions for child abuse. That would include convictions of, in some cases, contributing to delinquency of a minor. It would include, in some cases, abduction, which you oftentimes will see people charged with when they won't let someone leave the room during an argument, or brandishing a firearm. So it's not just domestic violence charges. It's all of what we call predicate offenses. If you have any of that before filling it out, give me or one of the other attorneys in Virginia that practice firearms law. We've got another firearms attorney on the board, Gilbert Ambler, and there's a couple of other attorneys that are well thought of around the state. But you certainly should get some advice before attempting to purchase a firearm or before filling out the concealed handgun application. And I will just add, what they're basing their prosecution on is when you sign it at the bottom of page 1, I, the undersigned, affirm that the information contained in this application is both correct and complete to the best of my knowledge. The willful making of a false statement constitutes perjury. And over again, when I'm representing people, I have them say, I didn't know, I didn't understand. Can't we just tell them it wasn't willful? And the reality is that whether or not willfulness was involved is the case law in Virginia is not great for defendants in that regard, right? Intent can be derived from action. And as someone who is being given a privilege that is incumbent upon politically active citizens, the courts tend to want to see them, put intellect into filling out these applications. So I absolutely believe my clients when they say that these are not willful misrepresentations. I don't know that I've ever had one where I thought the client had tried to put something over on the state. They truly did not understand. However, the fact that with a little bit of research and a little more in-depth reading, they could have understood it. The courts interpret that as willfulness. I see a note here. Be sure and mention medical marijuana cards. So let's mention that as well. And that's not just concealed handgun permit. That is firearms ownership overall. Marijuana, despite the fact that it's decriminalized in Virginia, as well as having a medical marijuana card regime in Virginia, is still categorized currently at the federal level as a controlled substance. And so if you are an illegal user, and by definition, if you're a user then of marijuana, then you are prohibited under federal law from possessing, purchasing, or transporting firearms, and therefore you are an illegal user of the marijuana. Even if you have a Virginia medical marijuana card and you're using. So those of you that have those cards, here's some things I'll say to that. Number one, just because you have a medical marijuana card does not mean that you are actively using, number one. I had a call one time from a reporter who had gotten a card so that they could write an article about the process of how one acquires a medical marijuana card. And they were subsequently going to relinquish it. They were afraid they had impacted their firearm rights. The other thing is a medical marijuana card issued by a medical provider is a medical record protected by HIPAA. So, as an attorney, the number one thing I have to say is I will never advise you to break the law. And I will never advise you to make a false statement on a form. But I'm asked all the time, how easy would it be for a prosecutor to know whether or not I have a medical marijuana card? It is not something that, to the best of my knowledge, is uploaded to the NICS system. And I think there'd be significant HIPAA implications if that were to ever occur. And therefore, certainly a subpoena could get that information if you were already suspected of some other crime. But this is a very gray area. And I think the best thing that will happen to everyone, those that use marijuana for pain remediation or for other medical needs, is for the federal government to get off their can and get the decriminalization done at the federal level sooner rather than later so that we don't have this gray area anymore. But just be aware of all those little fine details when you're making your decisions about that. And I know I've went on very, very quickly here. So I've thrown a lot of information out here. I've seen a lot of comments come by, and I haven't really had a chance to look too closely at questions. I'm at that age of life where multitasking becomes a little bit more difficult. Let's see if have any of you saw any questions that you want me to address?
Yeah, hey John, let me steal you first. Got a few questions for you. Why now? Why all of a sudden is this effort of all these people getting charged with felonies? Why now?
I don't have a good answer to that question. I actually asked, I mentioned that the person who was prosecuted just a couple weeks ago, or we had the preliminary hearing and resolved the matter a couple weeks ago, and I asked the Commonwealth attorney or the assistant who was handling the case in that matter, why they chose to file charges in this case, and the answer was very unsatisfying, if you will, and that is, we want people who we are going to entrust with a concealed handgun permit to be the kind of people that can follow instructions. And again, that's the answer that I got from the assistant Commonwealth who was handling that case. Now, they did, in fact, offer a resolution to that case that was very acceptable to my client. So it's not like because remember, a perjury starts off as a felony, and technically they have all the elements necessary to drive that all the way to circuit court and to trial. And usually that's not what happened. It's more along the lines of, we're going to go to a preliminary hearing and, we're going to make sure your client never makes that mistake again. But why they've started doing this on CHPs, it's long been a policy of the state police to prosecute those that attempt to purchase and make a false statement, even inadvertently. But this is local prosecutors that are starting to make that.
Do you think there's some kind of a coordination going on there? Any kind of a common ground? Are these Soros prosecutors?
No. And again, these are not prosecutors that ultimately end up trying to hurt the clients badly. I mean, again, prosecuting them at all for making these mistakes is hurting their lives. It's costing them money of representation.
Scaring the hell out of them.
those who've been involved in the criminal justice system in any way, or those who practice law, will understand there is sort of we're going to make the process the punishment, but we're not going to end up ruining their lives. And then we're taking this all the way. And this is not we're taking this all the way prosecutors where I'm seeing this. So I don't know that we're seeing it's so much a coordination as it is. What we oftentimes see is Commonwealth attorneys, police chiefs, clerks, all the people that make up the criminal justice system. They have various meetings and conferences and other things throughout the year. They share information just like defense attorneys do. And I think what we're seeing is people are saying, I'm so tired of having to send back 50% of my CHP applications or to deny them. And then they're tying up the courts with these Oratinis hearings to clarify the mistakes they've made. I think this is an attempt to, slap a few hands and hope that it will free up those resources. But that's my best guess. I don't have any better idea, but I don't think it's a concerted, coordinated effort, because we just seeing it just various places, and then other people in those same jurisdictions will make a mistake on a different question and they choose not to go after them. So I don't think it's coordinated.
Okay. Are there any particular localities that are a problem, or is it just unpredictable?
I've not had any particular localities where it's clusters. It's just seemingly happening all across the state. I travel all across the state doing cases, and it's all across the state. I might have one in Tidewater, one in Northern Virginia, one in the Richmond area, one in Southside, one in Southwestern Virginia.
Okay.
So I have a couple of questions. First off, C&T Designs and Arms, you asked earlier, what do they do about first offenses? If you can clarify that a little bit in the chat, that would be good. But John, one of the questions that we get very, very often is people that are renewing their CHP, and they took an online course back when online courses were permissible. And they want to know how to answer that question, because there's not a not applicable box, at least not yet. We've asked the state police to fix that question, but we've had clarification from the Attorney General that only applies to new applicants, but it's still confusing on the form.
So my advice to my clients is, if they're doing a renewal and their previous training was not in person, they answer that question no. And if they're doing a paper form, they write renewal underneath it, just somewhere near that question. If they're doing it using something like Permitium, then when they get to the text box over on page 2, they put a note somewhere that I answered this question no, because it's a renewal. And I don't know for certain that Permitium even asks that question if it's a renewal. But again, you have to answer it truthfully. And then if they deny it, then we can explain it at an Oratinis hearing. But given what's been happening, we absolutely don't want to say yes because that's what they want to hear. We want to be completely truthful.
Okay, so C&T Arms, Design Arms, is someone charged with a felony but gets a sentence of first offender, meaning if they do their sentence, the felony is dropped like it never happened. He's asking about that.
Sure. So a couple of things. First of all, that is one of the most common questions I get asked a lot of times by people, and that is, people really have trouble distinguishing from a legal perspective the difference between the word charged and convicted. So, for example, and we have a number of different things in Virginia where we can resolve a case that isn't a conviction of the original charge. So, for example, if somebody tries to buy a gun today and 20 years ago they had a TDO followed by voluntary admission, they're going to originally get charged with felony false statement on a consent form. and their record from that point forward will show a charge. And then each charge on your record, unless a jurisdiction drops the ball on getting the data back to the state police, but each charge on a record is going to then ultimately have a final disposition. So, for example, a first offender program where you maybe do some community service, you don't get in trouble for 6 or 12 months, and you pay your fines, and at the end of it, they dismiss the charge. That's a dismissal. That's not a conviction. You were never convicted. Same thing with, deferred disposition, which is one of the things that as a defense attorney is sort of like our favorite tool in the toolbox. We use those all the time. It's similar to a first offender program in that we lay out some terms. You can't get in trouble. Maybe for a year you have to report to probation and parole. You have to get some drug screens, depending on the charge. And at the end of that period, if you satisfy the terms of the deferred disposition, the charge is fully dismissed. You were never convicted. So during the time that you're on first offender or you're on deferred disposition, you'd want to answer question J, or I'm sorry, not J, not J, K. Do you have a criminal charge pending? Yes, you do. You have a criminal charge pending because we've not resolved it. You have to wait till the end of that. But at the end of that, when the judge enters the dismissal order, you are not convicted and you don't have to say yes.
Okay. John, it really bothers me that it seems like a trap that we have these two ways that you answer if you've been had your rights brought back. I think it really bothers me that on buying a gun you can say nope, never been convicted of a felony, but you better damn well say you have been if you're getting a CHP. Do you see any reason that we can't change CHPs to match purchasing a gun, or is there some reason that we have to go down this route for a concealed handgun permit?
Well, so if we set aside the fact that they've been prosecuting people for reading this wrong, I think the way that we do the CHP is good, because the reason we do the purchase form the way it is because the ATF already had that exception set up on the 4473. So we just copied that on the SP65 to make those two forms match, because otherwise nobody would get it right. The reason that the local jurisdictions are having you say yes and then include the conviction information, etc., is so that to make sure that if the jurisdiction where you're applying is not the same one where you got your rights restored, that they get a copy of the restoration order and they can confirm it. So I don't think the asking for it or even having the question structured this way is a trap. But I think the fact that they are charging people if they misunderstand with a felony to be a very, I don't want to say abuse of the process, because you are signing this under penalty of perjury, but I think it fails to understand the level of difficulty that many of our citizens have in reading. The font on this is about a 8-point font, right? I mean, you kind of need a magnifying glass and a Black's Law dictionary sitting beside you while you're filling it out. And then we have jurisdictions such as Virginia Beach that is making it such that you have to fill it out on Promedium, which makes it even more difficult to really understand the nuance. You're working through it on a screen, which, by the way, actually, those jurisdictions that use Promedium, in many cases, I've found are not the ones that are doing this, because it's harder to prove the willful intent when it was on a computer screen, whether or not they saw the instructions. But anyway, a lot of legal nerd stuff there wrapped up in this issue.
Well, but okay, on this Promedium issue, since you brought it up in Virginia Beach, we told our members, as I recall, you can still turn in a paper application, even though they say no. The law says you can do it, and if you do it that way, they cannot charge you the $5 Promedium fee. Is that correct?
And the clerk's office has acknowledged that. And if you bring in, they still will encourage very strongly people to use the Permitium application, but if you drop off a paper application, they, to the best of my knowledge, they've been instructed to accept it, and they will not charge the $5 fee.
Yeah, I think discourage the application is the correct way to put that. Oh,
Yeah.
no, we don't take that. Yes, you do. Well, all right, we'll take it. It's ridiculous, but I think, again, our members have to stand up. If they don't want to pay that fee, they need to stand up and do this. And if they have a problem, let us know, because these localities are supposed to accept the paper application, period.
Yes.
Yep. So Tom Jefferson said they could have a form for renewals only. Tom, the form is supplied by the state police, and the law specifically says that the state police develops the form, and that's what each locality has to use so that it's uniform. But perhaps we could recommend to the state police that they make a form for renewals that's slightly different from the initial application. I have to look at the code section, or John may know from the code section if it specifically says that it has to be the same form, because all of that is spelled out in the code.
I think they probably could have one. I think selling that, given that they have to design and get this, I think they have to do it in consultation with the Supreme Court to design the form. And I think selling that would be tough. I agree that would be clearer. I do see a question from DC Brian W. I don't believe there are any particular questions on the non-resident permit applications that would be significantly different. Now, the interesting thing there is those are processed by the state police instead of the local jurisdiction. So unless you made what legitimately would be some sort of willful false statement, I think the chances of the Attorney General actually getting involved to prosecute those is much less than the localities doing so, which is what happens with resident permits.
So I typically, John, tell my students that are taking a class in order to get a concealed handgun permit to pull up the form online, and it's a fillable PDF. And I suggest to them that they use the tab to move between the fields, because there's some tiny little boxes in there that are very easy to miss. And doing it that way, you reduce your chances of missing one of those boxes and having your application rejected. I've also suggested to people, and I was told this years back, but I don't know if the opinion has changed, that on renewals, you take them down and hand them in person, because then you can have an extra copy that you get time stamped and have a receipt that they received it. Is that what you recommend, or does that not matter?
I mean, it's always good to get a filed copy of the renewal to show that it was filed in a timely manner.
Yeah, I actually had one of the, not a clerk, but one of the people that works in the clerk's office refused to give me a receipt the last time that I turned in my application. I said, are you in the habit of refusing receipts for any other court filings? Because it's a court filing.
It is. It's a civil filing. It has a civil filing number. And, I hope that they backed off on their failure to give you a receipt.
No, she gave me a stamped copy of the application. And they also, she wouldn't take it. She didn't want to take it without me giving her a self-addressed stamped envelope. And I said, you charge the full amount allowed by law. You can pay for the envelope and the stamp. And she said, well, there's a chance that it might get addressed wrong. And I said, are you in the habit of sending out court documents with inaccurate addresses on them?
Yeah, you're brutal.
She was not happy with me, but that's okay.
She should have saw that one coming. She wasn't picking up on the first time, obviously.
No.
Just immediately went into my head and saw Pat having that conversation.
Yeah.
So, so
And then,
John,
of course, my husband was right behind me, and he handed him his application and no
Same
stamped
address. Same
envelope, and
address.
asked for a receipt, and she just went.
you should have brought. Yeah, too bad your son isn't here. You could have had it. You
I
know,
just do the whole family in one day next
Yeah,
time.
he's in a different county now.
I know. Yeah.
All
Um,
right. Any other questions that people have for John while he's with us? Because he's going to leave before the meeting is over. So type them in the chat. We'll give a few more minutes.
uh,
And Philip, you had something you wanted
yeah.
to
Well,
ask?
John, while we're waiting for our members to put something in there, you want to do a quick rundown again on the super safeties and FRTs. Just a brief little. I mean, just explain why the law is so screwy on that.
Yeah, I mean, so, this has been super controversial, right? Virginia, back when we got hammered with all of those gun control laws a couple of years ago, one of the things that got introduced was this trigger activator law. And, everyone on both sides thought that they knew what that law stands for. And it is an incredibly broadly written definition. And I've got an article on my website. If you go on to my website, and there's a search box on the right hand side of every page, and you just type forced reset, then it will take you to the article, and I explain why it is that I think this particular statute could be used if a prosecutor wanted to go after someone who had a forced reset trigger, the super safety, etc. And I kind of walk through the technology of those and why they're not really what was intended for it, but that I believe the definition could be expanded enough, and why I'm advising my clients to tread carefully. Because again, as attorneys, we see people get charged all the time with things that, really they should not have been charged with, even if they, we see gray areas. That's the type of charges that is so sad when you're helping someone, and it's not like they went out and just said, "Oh, there's a Lamborghini. I'm taking that Lamborghini home with me." That's a pretty clear-cut case of grand theft auto. But then you go to the other side of the coin, and it's like, Grandma loaned me her car. Grandma passed away. And one of the other beneficiaries under the will charged me with keeping Grandma's car. That's the gray area side when we're not talking about guns. When we're talking about guns, this is a perfect example. If a prosecutor, for whatever reason, wanted to get someone, this would be the kind of case where we'd have to bring in experts to talk about how these things function, why it's not a trigger activator, even though it affects the trigger because of this definition and this functionality and all of this, and things that those of us in the firearms community take for granted. We would have to train a judge and jury on. And juries are scary creatures. You just never know which direction they'll go. And so I'm advising my clients to avoid it, not because I think that it was intended for that function, but because I think it could be used for that function.
Yeah. So it's not probably technically not illegal at all, but you probably would end up winning the case if you got lucky with the jury, I guess. But the bottom line is, the people that want one of these just have to go in with their eyes open and say, have fun. Maybe you're in a locality where the prosecutor would never, ever do that. But if you're in Fairfax or you're in Alexandria or Arlington or whatever, just be aware that if there was somebody that wanted to take you to the woodshed. They could do it using this poor language. And even though you may ultimately win, you're still going to lose.
There's a saying in the legal community: the process is the punishment.
Yes, it is. Absolutely.
So,
Absolutely.
yeah, I think the couple of things to think about here is that even if you're certain that you could win the case if you're charged, you still have all of that time and legal expenses to pay. Um, and like you said, John, the process is the punishment. But just like when we go down and sit in on these committee meetings, the people that are making the laws have no clue what it is that they're talking about. You know, we saw it with the switchblade when they stuck in the prohibition on stiletto knives, and they were totally mistaken on what they thought a stiletto knife was, but they still banned stiletto knives. And the same with prosecutors, judges, and even probably a lot of law enforcement don't understand how these things work and what is a trigger activator and what is just an accessory for your firearm.
Exactly. I think Philip's summary is the best. Um, you just have to go into this with open eyes and understand where you are in the state, unfortunately.
Okay.
Yeah. C&T says lawmakers are some of the most uninformed people on the
Absolutely.
planet. Some of them are. Some of them are very informed and they take the time to research what it is that they're presenting. Others just throw it out there and see what sticks. You know, it's like spaghetti.
And I think the problem that we run into is just like any other niche group, right? So we're going in there and we're assuming that the lawmakers who are on the committees that affect us should know how firearms work, the intricacies of this, how ATF regulation and federal regulation already work so that they don't layer something that's incompatible, etc. And oftentimes that's not the case. I suspect the same thing is true when the CPA lobby comes in and they're trying to talk about some tax change that the lawmakers are working on in that committee. And they assume they would never do this because that would be contrary to IRS rule X, Y, and Z. And then the lawmakers attempt to do just that, which would fly in the face of the IRS regulation. So I think that is true. I think that it would be very beneficial if lawmakers who are assigned to specific subcommittees had access to more educational resources and took advantage of it about the topics that they're regulating.
Yeah, and you know, we've even seen the committees before. They were advised by the attorney that sits in the committee that the bill that they were contemplating was most likely unconstitutional, especially based on recent cases in other areas. And they passed it out of committee anyway. Sometimes they just don't care about that.
Yeah.
You know, a lot of times they're on the committees because they have an agenda, not because they know what they're doing. They have uh, a plan to follow. So I have not seen any more questions come through for you, John. I do really appreciate you taking time out of your busy schedule.
No problem. It was wonderful to be here, and I know you had popped up my website there. I've got a bunch of articles on there that people can search, and if they have any questions, it has my contact information on there.
Yeah, I'm
And
gonna pop it
I
up one more time there, and
and
I'll put it in the chat as well.
thank you. And hopefully, we can continue to help our members to avoid some of these common pitfalls.
And while you're here, I'll just give a shout out because those of you looking to take advantage of the fact that the tax on suppressors and so forth is going away the first of the year, John does trusts for $100 with lifetime updates, and they're excellent trusts. John, I assume you're still recommending that people use a trust if they're doing an SBR, SBS, or suppressor. Is that right?
Absolutely. Just because, so the original version of the Big Beautiful Bill was going to do away with both the registration and regulation requirements, at least at the federal level, which would have been its own problem with many states. But anyway, but the version that actually passed did away with the $200 tax stamp, but it still has the registration and all the regulations being the same, including the prohibition on sharing that the trust allows you to get around, the simplification when you pass away, etc. And I'll certainly be glad to answer any other questions for anyone. And as you said, the trusts are a flat fee of $100, and that comes with lifetime free updates, changes, and questions.
All righty. And I did put the website in the chat. John has a lot of very interesting and useful articles on his website. He's got like a blog page. So do go and check that out in your spare time. And we thank you very much for being here with us, John.
Thank you for having me, and I want to send a thank you out to all of our members, for being part of the fight to protect our rights. And I'll be back on a future one, I'm sure.
Yep.
Thank you, John.
Alrighty.
Thank you all.
Take care.
Take care.
Okay. Yeah, John, I don't know how that man does what he does. He's in a case in Fairfax one day, in Appomattox the next day, in Newport News the next day, and he's just all over the state.
Oh,
Now
yeah.
I know why he has a Mountain Dew addiction.
Yes.
Clear anything up, y'all. He's a busy man.
So, Philip, I'm sure you have a list of things you wanted to discuss as well.
Well, yeah. The case of the shooting that just kind of tore the nation apart. There's a video that I probably will put a link to in the next alert that explains what I thought was an anomaly. Like a lot of people, I watched, try to understand what happened and there was just some odd things that happened during that shooting. The shirt that was worn went up almost over his ear. It was like, why? And there is somebody that I think nailed the whole thing down. But what it turns out, and I believe this guy's got it right. Everything fits, and it suddenly made sense. It was a bulletproof vest that Charlie was wearing. That the top edge of it, the bullet hit the top edge of the bulletproof vest, and at that point broke up and ricocheted upward. And that explains all kinds of things. That explains the shirt jumping way up like this. And he actually showed like where the bullet hole went into his shirt. And then the shirt goes up, and then suddenly this gaping hole appears in his neck, which is unusual for an entrance hole to be big. That's normally very tiny. It's the exit that would be big. So the whole thing, it all fit together. I think this guy analyzed it correctly. I think, and I don't know if he didn't have the bulletproof vest on, would Charlie have survived? That's the question. I don't know. Maybe. Certainly might have had a better chance than getting hit in the either. I don't know if it hit his jugular or what. But anyway, I thought I was going to put that up there because I'm sure I'm not the only person that said that's. Why did his shirt jump up? Why did everything turn out the way it did? And it makes sense that he would be wearing a bulletproof vest. Absolutely makes sense. And I'm thinking that he had a rifle plate on top, but it just like 1 in 1,000, it hit the edge of that plate, and rather than stopping the bullet, it deflected it up. Anyhow, I'll put that information so you can look at that to try to understand. how that happened.
I saw someone expanding on that he wears a mic pack for his online, like he does like a recording to
Hmm.
go for, and someone was saying if he didn't have plates, more than likely that mic pack was like up on that upper part of if the vest or in that shirt area, and that's where because a lot of us, I mean, just in the firearms community itself, uh, it was, if you saw it, you will not forget it,
No.
Yeah.
because it was a
Oh yeah.
very large entry and it was awkward. It almost, not to be graphic, it it was almost gory to the point where you thought it wasn't real. It was like
Yeah.
a movie,
Mhm.
like what, a scary movie, Halloweeny,
I
and
think the bullet might have been tumbling at that point, maybe even
yeah,
hitting sideways.
yeah,
Uh,
just I think the impact is like where a lot of us are so used to the first aid, where you stay studied up on that. The impact is what made me this is legit, but at
oh
the same
yeah, there
time
was.
it's just kind of like, knowing what you're watching. But it was just, I mean, it's so many, I don't know, it's just a very sad, very,
Oh yeah,
traumatic
it's
Yeah.
thing. But
it's
looking into
really.
that, a lot of people, I've seen a lot of those questions like, why was it so big, like, and
I think
that was
this either one of the two explains it. But if you watch the video, it actually shows. Close up I hadn't noticed before, shows you can see the shape of the vest. Now he did. I think he had something on the other side that was sort of black. I don't know if that was the mic pack on the other side. There was something over there that I was trying to figure out what that was. But anyhow, it's a horrible situation, and of course, the usual suspects right away start calling for gun control.
yeah.
It's usually the ones that are provoking this kind of issue by,
Well,
And it's a
you know,
gun that they're arguing now, a gun that they were okay with,
oh
and it's
yeah,
like, I mean,
uh
that's the sad thing. And it
a
was
hunting gun.
also very sad, and I guess it's, coming to fruition, is we have warned in the 2A advocacy and the 2A activism, we have warned against this. This is something like this, and not to take away from the tragedy by any means, but something like this was going to happen where they were going to go after other forms of firearms that they at one time thought were the safer versions of,
We've been saying forever, if you're a hunter and you think your guns are safe, you're not paying attention. You're on the
exactly.
list. It's just that they may get to you a little later, but you're on the list of guns that they want to take away. They want you to be like England, where hardly anybody has them. If they do, they're not stored at your house. They're locked away at a club or something. So, yeah, you can count on that. But I think we're seeing a real change in the nation at this point. I mean, this really struck hard. I mean, I didn't know Charlie, but man alive, it just felt like I had my heart ripped out. And and thinking about his kids, his wife, and of course she came on, and I mean, boy, I don't know how she had the strength to get on and talk like she did,
And
but
I think, yeah, a lot of us in this community, I mean, especially when you are, you're a single issue voter, we try our best to stay as unbiased as much as possible. And personally, I mean, up until this point, I don't think that I probably could have counted maybe five actual full episodes of his podcast that I've actually watched in my entire life. Now it's wild to me. It I think what I'm most upset about, of course, I'm upset because a loss like that is just tragic. Whatever side of the aisle you're on, anytime something like that, you have someone that's taken so suddenly and so tragically like that, whether it be a school shooting, whatever you want to call it, it is tragic. And I think we all mourn for that. But at the same time, it's the amount of people that are so uneducated that have not necessarily have come out as just nasty and vile, for one, but also just those who are not, they are only paying attention to 15 seconds to a minute of what he said in the past. And I have sat down for the last, what, going on 3 days now, and I have dug into everything that has been said horribly about it, because I want to make sure that I'm making my mind up correctly. And I think that that's the worst part of all of this, is that a lot of things have been spread. And going back to somebody made a comment earlier about how these lawmakers don't know what they're talking about, and it all comes together. All of this, what we're seeing from the anti side, is it works in tandem. And this is, I hate to see where this is going to go coming up, especially us here in Virginia, being that it's an election year, how this is going to affect that. I
Well,
really, I really
people
care
are
about
fed
that.
up with all this, all the lunacy
That's,
out there, and
they really are.
I'm hoping that the gun owners say enough is enough is enough is enough. I'm getting out and voting.
Yes.
I'm gonna make sure my family gets out, my friends. We're going to get out and vote and try to make sure that this lunacy doesn't continue in our state. Enough of this. Enough of these people thinking that everybody that disagrees with them is Hitler. Enough of that. We're
Yeah.
done, and that's what I hope, that this will motivate, and young people in school as well, college, that are voters, get out and say yeah.
Yeah. So one of the things that has really impacted me the most, of course, the assassination weighs heavy, but watching the hate
Mm.
that people are spewing on social media, and knowing that that type of hate and that type of rhetoric is what spurns the next school attack or the next assassination of somebody that exercises their First Amendment rights.
Yeah.
And to see these people that just spew, he was a fascist, or he um, cohorted with sexual molesters, pedophiles and things like that. And these things, the hate that people are just typing randomly on Facebook and Twitter and all of that, is what causes people that are mentally unbalanced to feel the need to go out and do something like this.
Yeah, all this
So,
stuff about Nazi, it's a dog whistle to crazy
mhm,
people to do something.
Yeah.
right.
Not normal people, but that's a dog whistle. Every time somebody does that, I'm going, okay, you're trying to signal to somebody to do the dirty work that you're not able to do yourself.
And
Uh,
even those, not necessarily those that say it, but those that are agreeing with it. I want to say something from an instructor's point of view. That kind of stuff, especially if in public forums on social media, when if you're ever in a situation where you have to use your piece for self-defense, God forbid that you have somebody. I mean, I'm piggybacking off of having John with us tonight. God forbid you have somebody, a prosecutor that's going through all of your stuff, and they see you writing that. I
mhm.
mean,
Hmm.
that's just a little bit of morality there. I mean, I mean,
Yeah,
it, it's
and
these things are not just affect. I mean, like Philip was saying, I mean, it's a dog whistle. It actually triggers people even more. But at the same time, you are leaving a footprint on the internet in your social media life that is just nasty and vile. Why would you do that? And
uh, uh,
I'm an exposer. I mean, I'm a sleuth. I know better to redact myself and be careful as to what I say. I mean, it's just,
well,
oh my goodness.
Jill, let me ask you a question. I got an email from somebody that was irate that we gave our condolences to Charlie's family, and he said he's a racist and cussed me out. And I said I just sent him an email back. I haven't had a response yet. I said I've never heard that. I said we got 61,000 people, a lot of minorities on VA alert. Nobody but you has said that. I said just show me one, video, one statement where he said something that was clearly racist. I've not seen that. In your research, did you see anything? That would
No,
imply he was
no,
anything like
and
that?
I have had those comments too. People have said that, and very, very free. I'm one of those people that stand up for all of the A's in the Constitution. 1A, 2A, 3A, you name it.
Uh,
People have absolutely every right to express that if that's how they perceive someone. But I am going to say right now in my research, I have not seen anything like that. I've actually
Well,
seen more people of color coming up and saying, oh my goodness, I should have looked more into this before I said anything. I retract what I say, and it's a continuation of it's almost the same thing as the Second Amendment, where they're taking these little snippets of information that they're seeing because our attention spans are have been conditioned over the last few years or longer, ever since reels and vines
mhm,
and
mhm.
TikToks and whatever has come out. We have been conditioned to only pay attention to this much
Right,
when the real information is so expansive. We
right.
have the world at our fingertips. Do the research. That's all I ask. If you can find anything that, lack of better words, proves me wrong, please do that. Let's have a, and I hate to do that, and I've always kept my platforms open for civil, logical conversations.
Hmm.
I actually made a statement on that today. I'm I welcome that. I welcome that. Don't come like a jerk face because
mhm.
then you put me in a position where I have to take off the nice face. But I mean, I
Yeah,
mean that's just the thing. I mean, you don't mess with an exposer. You just don't do that. But at the same time, I mean, don't mess with someone's good nature just because you have a difference of opinion.
yeah,
This is going to. Did I like the guy? I mean, from the things that I've heard, yeah. I mean, from what I've seen on him, there's some things I don't really agree with. I think that has a lot to do with my own personal introspection, more so than anything else. But as far as him being a bold leader in the right wing, he's no different than David Hogg. I mean, come
Right.
on. And then I'm not saying, I don't like David Hogg, but at the same time, I'm not saying that what he's done is not successful. I mean, he's been very successful at lying and putting himself up there. It's tit for tat, in my opinion. It's just right now we are looking at someone who lost their life for speaking, for
yeah.
exercising their First Amendment.
Yeah, and I
For
think people on this, our members and us. I mean, if David Hogg got shot, I would not celebrate. I don't like anything he does, but I would never want to see harm like that. We cannot do that. First
no,
Amendment is something that's sacred. I think most of us would fight to make sure that even our enemies politically could speak
absolutely.
freely. And I'm not sure that some of our enemies would agree they would do that for us, but that's how we are.
And
Well,
that's the difference between us and them. And I can say that for us as far as the Second Amendment community as people that are advocates and activists for it. Um, we are fighting for a right for all people,
Yeah,
regardless if they disagree with us or not.
yeah,
We're not trying to restrict or control someone or push legislation to do that onto other people. We're not trying to, that should be like the sign right there. Like, okay, they want to expand the opportunity, in the 2A community for all of us to have it, regardless of our differences, regardless of our, disagreements, backgrounds, creeds, whatever. Whereas the groups like Giffords and Brady and March for Our Lives and Mom's Demand in every town and if whatever else screams enough and not one more. Here we had one more. Why aren't you mourning this? That's
right.
where the hypocrisy steps in, and I wish more people would wake up to understanding that there is a difference between us who are trying to expand the the opportunity, the choice, pro
Hmm.
choice, the opportunity to have this or exercise your your natural right of
I,
protection
I
versus
would,
Okay, so
controlling it, you know?
go ahead,
a
Pat.
couple things I wanted to point out here. One, um, I saw a video and I wished I had saved it. I'll have to go back and look for it. It was someone, Charlie does these, people come up and they ask him questions, and he has an open bait in front of thousands of people. So this particular gentleman came up and he opened his question with the fact that he was a liberal persuasion type of person, but that he appreciated coming to Charlie Kirk and having a discussion because Charlie allowed the expression of various viewpoints and actually had a civil conversation. Whereas if he went to left leaning groups and asked a question that was outside of their typical um, opinions, he got shot down. And he was not allowed to express anything that disagreed with what their normal is. So, the fact that people called Charlie a fascist or whatever and hate speech is ludicrous to me because he would talk to anyone about anything and have an open conversation with them.
He would even
But
tell the audience to be quiet and let the person speak if they interrupted.
yes, the other thing I want to say, one of the discussions that I had the day after, um, a friend of mine made a post and I answered his post and said, the hate has to stop on all sides. We have to quit fueling the hate. And this person came on and kind of attacked me and started calling me names and saying that I was supporting a fascist and so on and so forth. And he said, well, I guess you don't care about First Amendment rights. Well, one of the big arguments that we hear is that you can't yell fire in a crowded theater when there's not a fire. So the hate that people are spewing online right now is very much like yelling fire in a crowded theater when there is no fire. The difference is if you do yell fire in a crowded theater, you have to take the consequences of what happened. You'll be charged. When you're posting online like that and your words incite somebody to go to a school and murder innocent children or to assassinate somebody like Charlie Kirk, you're not culpable for that. I mean, you are culpable, but you don't have the consequences because there's no trail back to which comment it was that
The
broke
trigger.
that camel's back. So
Yeah,
be careful with your words, people. Words do matter. They mean
and
things.
and you make a good point, which has been coming up a lot lately. There's a whole lot of people crying on the internet that they lost their job because of the horrible comments they made about that assassination. And it's like, yes, the First Amendment keeps you from being arrested by the government for your thoughts, and with few exceptions. If your thoughts are aimed at assassinating a president, for example, they're going to come get you. But other than that, you're free to be hateful towards Charlie and his wife and all that. But that doesn't mean you're free of consequences, like you just said, Pat. That can cost you your job. That can cost you your friends. That can cost you a marriage. So
If
there is a price to be paid.
Yep, if somebody sees that online and if somebody sees that online that you work with and they feel like they or that you are letting out some sort of hostility, they can take that to HR in a heartbeat. I know that, as far as what's going on right now, there's more so people um kind of they're going in on these folks, and I'm neither here nor there on that end. But if somebody sees that you work with and they're like, oh my gosh, she like I don't even know who Charlie Kirk is, but she's praising somebody getting murdered on live you know, live television pretty much. I don't feel safe with that, and they go to work and they tell their HR, just, I mean, yeah, that's a consequence. I'm sorry, that's
I think it's been a
my
good
opinion, is
lesson.
fair.
It's probably a
Yeah.
good lesson to a lot of people out there that were thinking the First Amendment let them say anything at any time with no consequence. This hopefully will wake some of them up and go, okay, maybe they weren't thinking. Well, yeah, if I said something about you that was malicious, that was
Mhm.
totally untrue, and absolutely, and not just I think she might have robbed a bank. I say, no, no, Jill McDaniel robbed a bank back in 2023. That means you could sue the holy heck out of me because you didn't do that, and that's damaging to you. So
Yeah.
free speech, there are limits, and there need to be limits. You cannot do that kind of stuff. So I could say you act like you robbed a bank, though that's different. But for me to firmly say you did that, this is where we ended up doing a lawsuit for VCDL did because of accusations a while back. So they were false.
Yeah,
Oh yeah.
and I hesitate to say this because not all the facts are in, and we don't definitively know the motivation, although we have very strong suspicions.
Yeah.
But it appears that the assassin took Charlie's life because Charlie exercised free speech,
Yeah.
and in a way that did not hurt other people. He was not slanderous. He was not malicious with his speech. He just had open dialogues with people and stated his opinions, and he told the truth.
Yeah.
I mean, you shouldn't be assassinated for telling the truth.
Mm-mm.
Yeah.
That's something that the USSR might do, or
Oh yeah.
communist China, or something like that. It's not
Yeah.
supposed to happen here in the United States.
Yeah, people that spoke against Putin tend to end up dead from all kinds of unusual things like radiation poisoning because they drank plutonium or something. Um, yeah, but of course the rifle they found had inscribed on one of the cartridge cases, "Hey fascist, catch." I mean, it's pretty
I mean,
pretty
there's a
clear why what the motive was right there. And then that shows again they paid attention to each other. I'm sure he got all that stuff from the guy that shot up the school in Minnesota because he had, in his video he showed all these magazines. He wrote note after note after note of horrendous things about children. And then this guy sounds like he picked up on that and decided to be just as clever writing this stuff on his cartridges and stuff. Yet he didn't leave them out where people could find them. He hid the gun and was hoping to come back and recover it, apparently.
hmm
And that meant that cartridge that he wrote on there wouldn't have been shared to anybody. So
Yeah.
you don't really know. Well, again, maybe we're just dealing with trying to apply logic where there is no logic.
I don't know.
Why you would do that?
Um, we are at 9:15, and so we've run over a little bit here. I do want to mention the in-person meeting Thursday. Is it this coming Thursday, Philip?
Yeah, it is. It's this
Okay.
Thursday in the Ettrick Library down in southern Chesterfield.
And it's on the VCDL calendar, so you can look it up and get the address. It's 5:30 to 7:30. Am I remembering
Yes, that's
correctly?
right. Yeah, these libraries tend to close a little early, so we had to kind of move things up a little bit.
Okay. All right. So Gadsden Guns will be closing early. Just a heads up for you guys out there that might be watching in my neighborhood. Um, is there anything else that we need to cover?
Not that I can think of right now. I'm just gonna take a quick
DC
look.
Bryan says
Right.
Chantilly Gun Show is next weekend. So, and if
Oh yeah,
you join or renew um, outside, then you get into the gun show free. So, that's a good time to re-up because a lot of our members, their renewal is at the end of September. So, if you're in that area, Chantilly area, and are planning on going to the gun show, you can renew your membership and get into the gun show free for that day. If you're not in that area, jump online and renew, please, so we don't have to spend the money to send you out a paper notice. So we really appreciate that. That
Yeah, and
postage keeps going up.
yeah, it does. And I have another request. In other words, I have a request to put out another call for help at that show, at the Chantilly show. So while, certain shifts are full, not all of them are. So again, if you're up in Northern Virginia, or even if you're not, and you want to go up there and run a shift, that's a major show for us. I mean, it really is. We get more members signed up and more donations and stuff at that show than almost any other show. But we need to have the people there to man the tables. Otherwise, then we have to not have the table. So watch the alert; it'll be going out in a few days. But if you can volunteer to be at the Chantilly show, just send an email to gunshows.chantilly@vcdl.org, and that will go to Robert, who is running the show, and he'll put you on the list.
That was in the VA alert that came out yesterday also,
And
I think.
that's the one. It's going to come out again. So
Okay.
yeah, yep,
Yep.
big show.
All right, guys. We really appreciate everybody that stopped in tonight. We had some good questions in the chat. Thank you again to John Pierce for coming on and answering some of these questions and giving us a heads up on what to watch out for when you're filling out that SP 248 is the CHP application for
Yeah,
senior residents.
we're definitely blessed to have two gun attorneys on the board. So
Right.
we have 20. We've got access to anything the board needs free of charge, basically. As far as getting information, double checking that we're correct on the law. And so very lucky. So
Yep.
anyhow,
And Gilbert Ambler is the other lawyer, and he's been instrumental in fighting the ban in rust areas, the ban at ABC stores. I don't think we've done DMVs yet, which needs to be done, but
right.
that's on the list. He's also spearheading the lawsuits in the city of Winchester and Roanoke. And then we have the team that he's on. There's other people involved in the lawsuit against one handgun a month and the private sale background check and all of that stuff. DC Brian, next month the meeting will be at XCal, so I hope to see you there. That's the October meeting. Will be up in Ashburn at the XCal shooting range and fitness center. Fabulous place. So
Yeah.
if you're anywhere near there, make plans to be there third Thursday of the month. So unless anybody else has anything, thank you guys. Hit all the buttons and do all the shares and all the YouTube and Facebook stuff. Help us get the word out. And we appreciate you being here. So have a good night.
Good night, guys.
We'll see you next month.